Recording in
Yes.
progress.
A very good morning to all my dear students. Welcome to today's revisionary classes that we're going to start for all the CA intermediate students. On behalf of ICAI, I welcome each one of you, Vishal, Astha, Soumya, Shagufta, Almas, all of you. A very good morning, children. So I hope you are extremely excited because your revision is starting now, and we all know that being consistent with hard work is the key to success. So ICAI has very beautifully helped you in completing all your syllabus. We have been practicing questions also. And now we'll be starting chapter-wise revision in which we will make sure that you get to learn many number of questions which are examination-based questions. So together we have to make it a success. But one tip that I want to give you is that yes, you all know hard work is must. Day before yesterday, the result has come and you have seen how beautifully the students have scored. It's only if you are consistently working, you're revising, you're making a study plan, keep making your notes, even if you have not made yet, you understand anything in the revision, keep your notes open along with the revisionary classes and keep adding the things in that. Another thing is MTPs, RTPs is very important. It's all about retaining the information here and using it as a memory game. So I hope you all will be doing that. As and when every chapter is being revised, we will be taking up number of questions, but please keep on doing your MTPs, RTPs also. So today's session, we'll be covering a brief touch-up of preliminary, that is important definitions I'll be going through because since it's a revisionary, so we'll pay more stress on your questions that we have to take and few of the important definitions that I wanted to do with you. Also, there will be number of question answers rounds because it is your revision, so you have to answer many of them. So what is a company is a very basic thing which we have been doing. Applicability of Companies Act is also very clear to you. So my question is Companies Act 2013 completely applicable to banking companies? What would be your answer if I ask you? If an MCQ comes that banking companies, it's completely applicable, what would you write? Absolutely correct. Except the provisions when it is inconsistent with the banking regulations, there it is not applicable. Otherwise, for all the banking companies, it becomes applicable. All right, correct. Let's move ahead. So regarding definitions, children, if you ask me how you have to revise the definitions, a flip through of the pages of study material is must. Don't try to leave a single thing कि चलो ये तो आएगा नहीं या ये छोटा सा है इसको रहने देते. Each and every line which is written in the module, I always keep telling you, it is very, very important. So just give a read through to these definitions. So first important definition that we're going to revise it because I have a question related to this is an associate company. So quickly write down in the chat box, is it 20%, 25% or 51% in order to become an associate company? How much percentage is required? Dhruv says 20%. Soumya says 20% or more. Mohammed Farhan, Athar, very nice. Everybody has answered it correctly. Rambi Shah, good. 20% says Julie Kumari. So if A Limited is having a significant influence and holding 15% shares of B Limited, can we say A Limited is an associate company with B Limited? Yes or no? Absolutely correct. And if A Limited is holding 49% shares of B Limited, is it an associate company or a holding company? Very good, Mohammed Farhan, Tanisha, Yushi, Almas, Julie, everybody has answered it correctly. Praveen, Shagufta, good. It is an associate company. So we all remember, and if I'm not holding any percentage, I'm controlling your business decision making, then also it's a associate company. Also, we have understood that fiduciary relationship will not be considered while we are counting the associate company. So here is the first case study that we are going to do. I told you the revisionary classes is all about examination point of view. We'll be revising the content. So it will be more of the question answers round rather than just, revising the content. So I am assuming that you all have revised and we are sitting here for having a quick recap of the question answers. So if ABC Limited has allotted equity shares with the voting rights to XYZ 15 crores and convertible preference shares worth 10 crores, after that, the total share capital is 100 crores. Can we say that the XY-led would be an associate company? See, now examiner is asking you two things. First, she's asking you whether they are an associate company. And the second question is also define an associate company. Now, how you have to write the answer is very, very important. Don't please give a conclusion, yes or no in the exam. You have to lay stress about how you have to present your answers. Okay, so I give you 1 minute. Frame your answers because it's a very simple question. You can, for the chat box, you can write me yes or no or what is the relationship. But what would you write when I say define an associate company? So since we are here trying to learn how to memorize the things, so how we have to remember and how we have to write, how the two companies are related to each other. So a company in relation to another company means a company in which the other company has a significant influence. And this line is mandatory, children, which is not a subsidiary company. Because ऐसे तो फिर we know that there is a subsidiary company also having a relationship, right? So for the associate company, it is mandatory to line this right. So all these highlighted points are very important for you to understand. Having a significant influence, which is not a subsidiary and includes a joint venture. Then you will give the definition of significant influence, at least 20% of the voting power or controlling or participating in the business. Then joint venture one line and fiduciary capacity should also be laid stress as it is a part of the definition. So this is how you have to write your answers. Associate company in relation to another company having a significant influence. And very important thing, the basic reason why we are having this session is to make you understand how the paragraphs are to be divided. Provisions of the case, facts of the case, and the conclusion. Very, very important. These three paragraphs is very, very important. So in the instant case, ABC has allotted equity shares worth 15 crores and preference capital shares 10 crores out of the total. So 15 plus 10 would have been 25. But what are we assuming over here? We are saying equity shares are having voting rights. We are not counting preference shares as they are not having voting rights. He has specifically laid stress on the equity shares with voting rights. Therefore, it is less than 20%. Hence, we will not consider as an associate. Now, you want to write an assumption? Please give a clear-cut assumption that yes, we assume here that the preference shareholders are having voting rights. Then it will be an associate company. Please note down this important point in the solution. It is very, very important to give exact solution, exact assumptions, whatever you write. Okay. So Almas, Soumya, Khushi, I have read your answers, children. Absolutely correct. All of you have mentioned. So along with the reasons, you will have to lay stress. If you're saying yes, then what's the reason? If you're saying no, then what's the reason? This is the way you have to give the answers. Fair enough. Let's do another case study. ABC has allotted equity shares with voting rights of 15 crores and issued non-convertible debentures. Read it and give the answers. All right. So the whole story is about non-convertible debentures. Are we going to include them or not? So it says first you will give the definition. then he has allotted the equity shares less than requirements. Non-convertible debentures has no relevance for finding the significant difference because we only considered equity and preference. And preference also, if you're assuming that they are having voting rights, then you will consider. Otherwise, preference shares are also not. Anyone having any doubt till here? Then auditing and accounting standards is very, very simple definition. Classification of capital. Okay, one question I'm going to ask you. What does the meaning of nominal and authorized share capital? If 2 marks questions come in the MCQs, is it the capital with which we are doing the business? Or it is the maximum amount which is mentioned in the memorandum of association? What is that? Yes, Astha Sethi, absolutely correct. Your answers. It's a registered capital. Mohammed Farhan, this is what you'll write. If teacher is asking you, what is the meaning of authorized share capital? You have to give the meaning. Absolutely, Almaz. It's the maximum amount that company can issue. Whether it issues or not, that is a separate story because then you have your issued capital, then you have your subscribed capital, how much is taken up by the public, all these things. Okay. Then we had body corporate. You have revised it well in the LLP also. I hope no doubts in the body corporate's definition, books of accounts. These are all simple definitions. Company limited by shares and limited by guarantee. So what is the meaning of company? There was a company which was formed in year 1981 and Reliance which was formed in 1973. But Companies Act says it is a company incorporated under this act or under any other previous company law. So 2 marks question, will you call Reliance Industries Limited and Infosys Limited also company because it was registered under previous company law? Yes or no? Absolutely correct, because you will give a definition of the Companies Act and lay stress on this. Now let's come on another important topic, that is holding and subsidiary relationship. I'm not going to teach you. I'm going to ask you. Anyone would like to raise their hand and tell me what is the relationship between a holding and subsidiary company? Anyone would like to explain? You can raise your hands and explain what is the meaning of holding and subsidiary company. We have just completed case studies on associate companies. Now I'm asking you about the holding and subsidiary relationship. Who is going to raise their hands and tell me, or you're going to write in the chat box? Okay. Soumya has written. Almas. Okay. Yukta would like to speak. Yes, Yukta.
Good morning, ma'am.
Good morning, Yukta. Be loud.
Ma'am, subsidiary company means a company in relation to which another company holds, controls the composition of board of directors or control more than one half of the total voting power.
Yukta, my question to you is, if I'm not controlling your board of directors, but I'm holding 53% of the share capital in your company, do I become your holding company? If I'm a company, do I become a holding company for your company? Yes or no? Others can also type in the chat box.
Yes, ma'am, because both these conditions are an option.
Very good. Excellent. Thank you so much, Yukta. Great. Yes, Shagufta, you want to say something?
गुड मॉर्निंग मैम.
Good morning.
मैम होल्डिंग कंपनी का ही डेफिनेशन आपने पूछा था ना, वही बताना.
हाँ जी बेटा, प्लीज.
होल्डिंग कंपनी in relation to one or more other than company means holding company on which company as a subsidiary company 51% holding shares.
Oh, is it 51%? Are you sure? Or what do we have to write? What is written in the law?
51% or more, ma'am.
Are you correct? It is more than half of the total voting power. So you have to use the correct statement. Okay, you will not. 51% or more is in case of government company. Here, Shagufta, we have to use more than 50%. You're right in your concept that it has to be more than 50%, but for the law, you have to write the exact language. All right?
Okay, ma'am. Thank you.
All right. So let's have a quick recap of holding and subsidiary. So it says either you're controlling the composition of board of directors or you are having more than half of the total voting power. Then you become a holding company, and the company in which you're holding these shares is your subsidiary company. And if A is a holding of B and B is holding C, can we say C is subsidiary of A also? Yes or no? Absolutely correct, because subsidiary is also your subsidiary. Let's do this case study 3. It is related to your holding and subsidiary. So another thing that I wanted to explain you, why do we say holding company in relation to another? Because that is what is the association relation between the two companies. Till the 20% they are associate, more than 50% they become holding and subsidiary. Now read this and give your proper answers in the chat box. Everybody, even the students who have joined now, welcome to the class. So we have just done 2 important definitions and now we are doing a case study based on holding and subsidiary. Everybody will read the question and write the answers in the chat box. Yes. So what is the twist in this question? Paid-up share capital is 1 crore, 8 lakh equity shares, 2 lakh cumulative preference shares. XYZ and BCL are holding 3 lakh and 1,50,000 in AVS Private Limited. What is the total capital? Out of 1 crore, how much are they holding? 3 lakh and 4 lakh. 4.5 out of 10 lakh. Is it a holding and subsidiary or not? So see, I have highlighted the question in bold. How the examiner is giving you a hint whether AVS is a subsidiary of TSR. What would be your answer if TSR has 8 out of 10 directors appointed? So he is trying to give you a hint that if this relationship of percentage does not work, do we have anything else to be considered? So I have around 51 answers in the chat box, out of which I'm just going to read few of them. Otherwise, it will take so much time. Okay. Yes, Vishal Chaudhary. Yes, that is great. 51 or more is for the government company. %, Jayendra, have you written for the previous one? Where are the answers for the current? Priyanshi. All right. Yes, 2 layers of subsidiaries is absolutely correct, Priyanshi. Okay, so I have an answer from Anjali. All right, good. Students, I'm looking for your answers for case study 3. So please type your answers. Shifimol. Yes, more than 50% has to be seen. All right. So since most of you have given your answers, so here is the correct answer and the way of presenting the answer. So first, children, we will write down the provisions, how the subsidiary company has a relationship, when the company is considered to have a control over the composition of board of directors, or the company is holding more than 1/2 of the total voting power. Here, XYZ and BCL are subsidiaries. उसमें क्या पूछा था? AVS is a subsidiary of TVS. So he has said XYZ and BCL are subsidiaries because they are holding more than the, so out of 8 lakh they are holding, okay? 8 lakh equity shares were there. So out of 8 lakh, you're holding 4.5 lakhs. So yes, you become a subsidiary. So now since you have become a subsidiary, so in aggregate of AVS, the total voting power out of 8 lakhs, you're holding 4.5 lakh, which comes out to be more than 50%. We conclude that TCR is holding majority of the voting power, therefore it becomes the holding. Now, if it is appointing the board of directors of AVS, then such way because it is controlling the board of directors, again it becomes the holding company. So in both the cases, the yes answer was the correct answer, but you don't have to write just yes. Very good, Yukta. Now the answer is correct. Shifa, everyone has written the correct answer. Tanisha, Ayushi Verma. So simply yes nahi likhkar aana paper mein, you will have to explain, you have to give the solutions like this. Okay, now let's jump to private company and public company. So you remember the important definition of private company, 3 important points. It restricts its number of members to 200, it prohibits, and it has a restriction on the transfer of shares. So if there is a public company which is having 245 members, their directors and relatives are 190, employees are 15, ex-employees were allotted shares 20, others are 10, including 10 joint. Can you convert it into private company? Read the question very carefully and give me a correct answer. Do we need to reduce the number of members? Yes or no? And what is the total number coming out for the private companies calculation? Yes, absolutely correct, ma'am. Past and present employees will not be included. Very good. For the joint shareholders, you have to count them one. So how many of them are there? Please see correctly. Good, good, good. Are you sure the number comes out to 200? Please read it correctly. 190 is the number of directors. I agree that 20 and 15 are not to be included. Out of 20, there are 10 joint shareholders. So these 10 joint shareholders will be counted as, how are you going to count them? Yes, how are you going to count them? See, there is a restriction on including the private company by its article limits the number of members to 200. So if 2 and more persons are holding 1 or more shares, they will be treated as a single member, and people who are in the employment are in the former employment, means in the past employment, will not be counted. Everyone has to write this definition when such a kind of question comes. If you are not writing the definition, you are simply telling them that the number has to be 200 and yes, it can be converted, you will not get marks. So you have to learn, and the way of representing the answers is something which is very, very important, something which we are trying to lay more stress now, because we are assuming that you have prepared well, you are revising your content. Now we are preparing you from the examination point of view. So presentation of answers is very important. So 2 or more persons. So there are 20 persons who are holding joint shares. So they will be counted as 10. Okay. So since 190 number of directors, 10 are the joint, how will you write? ABC has members, directors, 190, past and present employees were not counting, and 10 joint shareholders, which are in line with the requirement, following restrictions of directors holding constituting 200 members. Therefore, it can be converted into private company. It can be converted into private company. ABC, when converted, will not be required to reduce the number of members because it is fulfilling the condition of 200. Students, देखने में सिर्फ एक वर्ड का आंसर है, सिर्फ एक लाइन, 200 नंबर ऑफ मेंबर्स. लिखना कैसे है, that is something which you have to understand. Okay. Okay. Now, what is the definition of small company? So if I ask you, since we are doing question answers, So there is a company ABC Limited, which is holding share capital of 3 crores and 40 crores. Is it a small company? Almas and Dhruv, the previous answer was correct. Asta Sethi, everybody is correct. Absolutely correct. Khushi Gupta. All of you, very smart students. No, ma'am, it is not a small. Muskan, wrong. All of you have given the correct answer. Bhumi Agarwal, Soumya, Mrs. Saxena, 200 members was correct. Jayendra, absolutely correct. So it is not a small company because public company is never a small company. So I've also written small company is always a private company. Let's take another example. So ABC is a private limited having a share capital of 3 crores and turnover of 30 crores and is holding more than 50% of share capital of PQ Private Limited. Can we say ABC Private Limited is a small company? Ram Dulari says no. Others also say no. Why are you saying no? Please give me the reason. Children, please start giving the reasons. No, because small company is not applicable to holding and subsidiary company. Absolutely correct. Neither it is applicable to Section 8 companies, neither it is applicable to public companies, nor it is applicable to holding and subsidiary company. And what is the limit? Okay, now last question. A private limited company, it is not a holding or subsidiary, it is not a Section 8 company. It is having a share capital of 2 crores and the turnover of 50 crores. Is it a small company? No. Why Soumya says no? What's the reason? So no is very easy to say. Give reasons also. Anjali says no because it exceeds. Very good, Yukta. So you have to give. There should be and. Yes, Vishal, Muskan, everyone is correct. So the condition, both the conditions have to be satisfied. Very good, children. Very good. So we have done 5-6 questions related to small company and all of them were correct. Give yourself a patting from us. Now, financial statement related also have a question case study for you. So there is a company's extraction of Smart Solutions Private Limited. This is the case study which came in July 2021 question paper. So there is a paid up share capital of 50 lakhs divided into 5 lakh equity shares. There is no change in the paid up share capital after that. And there is a turnover of 2 crore. So 50 lakhs is the share capital and 2 crore is the turnover. There is a company, Nice Software Limited, which is a public company. It is holding the equity shares in the fully paid Smart Solutions. Sorry. Holding 2 lakh equity shares. Smart Solution has filed the financial statements with the ROC and they have not filed cash flow statement. Now you remember what was the provision of financial statements? You want me to revise it with you first? Financial statements means balance sheet, P&L, cash flow statement, and the changes in equity and any explanatory statement. What were the three companies for which CFS is not compulsory? What are the three companies for which CFS is not compulsory? That is, cash flow statements is not mandatory. Everyone, small companies, Section 8 companies. Are you serious? Financial statements of dash, dash, and dash may not include cash flow statements. What are those three companies? Excellent. OPC, small company, dormant companies. Now I'll show you the answer. So everyone has given the correct answer. If you're an OPC, it is not compulsory. If you're a private company, which is a startup, it is not compulsory. If you're a dormant company, it is not compulsory. So small company also. So there are 4 companies for which it is not compulsory. Okay. So now you solve this question very carefully, all of you. So if you're a company which is a public limited company, you're holding the equity shares. Smart Solution is having the financial statements. They have filed. Notice has been received that Smart Solution has failed to file the cash flow statement. Whether it is deemed to be a limited company whose significant shares are held by a public company, whether it has defaulted in filing the financial statement. So what kind of 2 concepts are to be considered over here? Can you tell me the name of those 2 concepts? What 2 definitions? What 3 definitions, in fact, we are going to use? So many a times we think preliminary is, or just about the definitions. 1 or 2 questions might come, might not come. Just see how systematically the questions are coming, and so beautifully they have framed this question in July 2021 paper, which is involving 3 conceptual definitions. One is your holding company, one is your reference of small company, another is financial statements. So let's see the answers, how you have to present it. So if you don't remember, children, section 2, clause 85, it's absolutely fine. What do we write? As per the provisions of Companies Act, small company is having the paid up share capital less than 4 crores and the turnover as per the P&L will not be more than 40 crores. However, nothing will apply to a holding and subsidiary. So what is the subsidiary company? If you're holding more than 50% of the shares, then you become holding subsidiary. But small company cannot be a holding or subsidiary. Now, what is happening in this question? He says, Nice Software is a public company. First of all, you're a public company. Then you're holding 2 lakh equity shares out of 5 lakhs. So it is not a subsidiary. Hence, it is a private company and not deemed to be a public company. So, see, child, if you are holding another company, then I told you, you become the subsidiary of another. And if a public company is holding a private company, then private company shall also deem to be a holding company. But here you are not holding it. Huh? So it is not deemed to be a public company. It remains private company only. Now, since it is a private company and it is having within the limits of the small companies, therefore, Smart Solutions is a small company. Everyone agree with this? You can write yes if you agree with this. Clear this point? Everybody is clear? Very good. All right. So now, what is the second part of the question? Now, since you have been categorized as small company, have you defaulted? Now, he asked you whether Smart Solution. So, since Smart Solution is a small company, you will give the definition of financial statements. Tell them why you saying no, right? This kind of question comes for 7 marks or 6 marks. You have to give them these three definitions. So one definition of small company we have used, one definition of subsidiary company, another definition of financial statements we have used. You will give the definition. Since it is a small company, therefore it is exempted. Hence, not filing the financial statements, it has not defaulted in any of the non-filing things. Is it clear to everyone? Was it a good question? Okay. Now, financial year, I hope you remember financial year. Only one case study I have because November 2019, again, this question has come. So read the definition related to financial year because we have to do entire incorporation also. So we'll not put much of the time. So SKP Limited is a wholly owned subsidiary and it follows a different financial year for the consolidation of the accounts. What is the procedure to be laid down? Now, this is a straightforward question which has come in the way of a case study. So central government's application has to be made if you're having a company which is registered outside and you want to consolidate your financial statements, then an application can be made to the tribunal. If tribunal allows you, you can follow a different financial year. So here we are assuming that it is a foreign company which is registered outside India. That is why the reason we have to use CFS, even when we did companies incorporated outside India, you remember we have done this kind of provisions related to the consolidation of the accounts. Then one case study of government company I wanted to do with you. Quickly read the question and give me the answers in the chat box. What do you think, whether it is a company which can claim the status of government company? Case study 7, 51% of the shareholding has to be same children for the government company. State government of X is holding 48 lakh shares. Total paid up capital is 95. What should be the 50%? Do it in your books. Tell me the correct answer. Can Z claim to be the subsidiary of Y Limited because it's a government company? Give me the answers. Soumya, Almas, all of you have given good answers for the previous one also. Dhruv, Julie, Asta, very good. Because now children, I have to go into one of the chat and click it and read it. So it becomes really difficult. But please giving your answers. Because that is the only way you will learn. Very good, Muskan. 51% is the condition. Here it is only holding 48%. So one point is clear that it is not having a holding subsidiary. It is not a government company. So let's read the answer. First, you will give the definition of government company and then you will give the definition of holding and subsidiary. Then you will conclude, since you're only holding 48.5, hence Y Limited is not a government company. And further, Y is holding 50% of the shares of Z. Therefore, it becomes subsidiary. But Z is a subsidiary of Y, which is not a government company. Therefore, it is not. It is also not a government company. So why was this conceptual question taken up, children? Because always if you are a government company and you are having any subsidiary of yours, then only that subsidiary will also be considered to be a government company. Let me see if we have any more questions. KMP's definition you will do. Okay, 2-3 case studies I have more, but I want to jump to related parties definition also because we have only one lecture scheduled for these 2 parts. Net worth, do you remember what was the definition of net worth? Write down in the chat box. What 3 things are to be added and 3 to be deducted? Do we need to consider the revaluation assets and write back of the depreciation while calculating the net worth? Very. No, it is not to be considered. Good. Mohammad Farhan, Mohammad Parvez, Tanu, Nidhi, Tejshri, Prasad. Everybody have given the correct answer for the previous one also. Well done, students. So paid up share capital reserves and security premium has to be added, reduce the losses, deferred expenditure and miscellaneous expenditures, but revaluation reserves will not be considered. Officer in default, promoters, now related party, you want to do, somebody said that, ma'am, we want to revise related parties definition. So a company who is having a director or his relative, they both are related to each other. Any KMP or relative of the company is also related to each other. If you are a company ABC Limited and there is a firm PQR Associates in which Mr. A, member of a company, is also a director. So he's a partner in company in a firm and he's a member in a company. Can we say that they are related? That company and firm is related? Yes or no? I will stop the screen share so that I can read your yes and no on the chat box quickly. Tell me, are they related party? Yes or no? Again, your answers are not coming. Very good. Excellent. Yes, now I can see. Yes, they are related. When I close the screen, then I can see your answers popping up immediately. Otherwise, I have to go into one chat and see. A private company in which you're a director. So I am a director in ABC Limited. I am a director in AB Private Limited. So ABC Limited and AB Private Limited will be a related company. If I am a director and I'm also holding 2% of the paid up share capital along with my relatives in another public company. So if both these conditions are being satisfied, then also these two companies will become a related. Or on the advice or instructions, so I am giving the advice and instructions of I am ABC Limited's director, and on my instructions, PQR Limited is also acting. Therefore, ABC and PQR Limited also becomes a related party. Is that clear? And the last one, the complicated one, is if you are having a holding and subsidiary companies director, then also you are related parties, associate companies, joint ventures. All these companies are anyways related to each other only. Okay? But this clause will not apply to a private company. A director other than independent director has to be considered. Now, on this concept, we have a related party case study question which just came recently in May 2022. So I give you 2 minutes, just go through this related party concept. If you are a holding and subsidiary company and you're having common directors, you're a related party. Associate companies, related party. Joint ventures and investment companies are related parties, and subsidiaries are co-subsidiaries among themselves having relationship. That is also related party. But remember that this provision is not applicable to private company, and a director other than independent director or KMP of the holding or his relative has to be considered. So this was the concept. ABC Private Limited has 2 wholly owned subsidiary companies, D Private Limited and E Private Limited. However, whether these companies can be treated as related parties. So it says you are a private company, you are to having wholly owned subsidiaries company. So Section 2, Clause 76.8 of the Companies Act tells that any body corporate which is holding or subsidiary or a subsidiary of a holding company to which it is related, they are known as a related party. D and E are wholly owned subsidiary of ABC Private Limited. Therefore, according to Clause B, D and E are related parties. However, as per a recent notification, this clause is not applicable with respect to Section 188 to a private company, even if it is a related party. So you have to give the complete information. कहते वैसे तो related party है, but ये clause तो 188 वाला relate होता ही नहीं उसको related party, private company. What is the alternate answer given in your suggested answers? It says this clause is not applicable to a private company, although they are wholly owned subsidiaries and related parties. As per the mentioned, clause 8 will not apply. Therefore, they are not related. Simple answer. Everybody agrees to me? You want me to show it to you where it is written in the study material also? Some students are asking where it is in the module. I will just show you, children. I hope no more doubts in the preliminary chapter, because now we are going to head towards incorporation. Anyone having any doubts, you can raise your hands and ask me, children, because then we will jump to the incorporations. So here it is clearly written, children. This clause will not apply to a private company with effect from 5th June 2015. What clause? The clause of holding subsidiary relationship. So they have given you this question also. See, examiner has picked up the same question which is given as an example in the study material. So बच्चा बहुत जरूरी है स्टडी मटेरियल का एक भी पॉइंट छोड़कर नहीं जाना, समझकर रीड करके जाने सारे. ओके अब इस केस में अगले वाले क्वेश्चन में जब आप पढ़ोगे तो सब्सिडरी बनाता है उसको तो पब्लिक कंपनी बन जाती है. प्राइवेट कंपनी को एग्जेम्पशन है, बट अगर आप पब्लिक कंपनी हो तो आप यूज कर सकते. ये आस्था से.
Ma'am, in related party definition in 9th point, the director or KMP of the holding company and the director and KMP's relative is also a related party.
One case you have a relative, one case you don't have a relative. I'll just clarify to you. Let me just show it. So where you are talking about the clause?
9th point, ma'am, in study mat.
This one are you asking?
No, ma'am, independent director point.
Okay. In case of independent director, it is not considered to be a related party. If we are simply talking about the relative, I'll just show you this point. So it says, as per the Companies Act, subclause 9, a director other than the independent director. So first of all, you don't have to consider independent director or a KMP. Who is a KMP? All of the people who are there. Or his relative with relation to this will be treated as related party. So here, director's relative has to be considered, KMP's relative can be considered, but we are not talking about the independent director. So examiner will give you a question of relative of independent director is there. So you tell me, are they related party?
No, ma'am.
But if it is a relative of KMP, then they are related party?
Yes, ma'am.
If there is a relative of a director other than independent director, then they are related party?
Yes, ma'am.
Absolutely. Understood?
Yes, ma'am. Ma'am, in case a person becomes the shareholder once and then he joins the company as an employee, then he will be considered as a condition of 200.
Okay, so I'll tell you what happens. For the 200 members, if you were an employee and your share was allotted to you, you are not included because you're a past employee. But you were a shareholder, you have first taken up the shares, later on you became an employee of the company, then yes, you will be counted. So what has to be seen is shareholder is counted, past and present employees are not counted.
Okay, ma'am. Thank you, ma'am.
All right. So let's start with a new chapter, that is incorporation of companies. Now, since we have done the definitions, we have understood about the, where it is. Let me just open incorporation of companies. Yeah. So we will, children, first have a quick recap of your chapter, and then we will go back to the questions. Yes, Muskan, you can absolutely write section 2. There is no need to write clause if you don't remember. And another thing, Muskan, if you don't remember a section, you can simply write as per the provisions of Companies Act. All right, there is no worry of writing about the sections. So, introduction to the incorporation of companies and promoters. We have already understood in chapter number 1 who is a promoter. So promoter is the person who is named as a promoter in the prospectus, in the annual return, who is controlling the affairs and on whose directions you're acting. So basically, he's the person who has come up with an idea of forming a company, and he is going to form a company. How many number of people do we need for forming a company if it is a public? 7 or more. For OPC, do we need two people or one? For OPC, 1. What do we have to use behind the name of OPC? If I have opened up an OPC, so how will you write the name? Harleen bracket OPC Private Limited. OPC is always a private company. Small company is always a private company. Clear? Now, section 3 tells you the number of members, but what does section 3A speaks about? So these are all consent of nominee has to be taken. Do we need to appoint a nominee? If you're a OPC, yes, a nominee has to be appointed and his written consent has to be taken in INC 4 form. And if you're trying to change the nominee, he can withdraw his consent also. Within 15 days, notice of withdrawal has to be given. Does it lead to alteration of memorandum if the nominee is being changed? Yes or no? MCQ question. Does it lead to alteration of memorandum is required if you're changing the nominee of OPC? Very good. No is the correct answer. If the number of members have reduced below the minimum number of members, remember this provision? How many time period, how much time period will be given to you? So section 3A tells you that if your number of members go below 7 or 2, if you carry on the business for dash number of months, you become severally liable. Who is going to tell me? Raise your hands and give me the answer. What is the time period to be seen? Okay, Tanu has raised. Anji.
6 months.
6 what? 6 years?
No, 6 months.
6 months. Okay. So Tanu, if I have reduced my number of members to 6 and I'm a public company and I carry on my business for 5.5 months, do I become severally liable?
No.
Why?
And 6 months later.
After 6 months, I become. Absolutely correct. Good. Memorandum of Association. I hope no doubts. It's very, very simple. Yes, Yukta, you want to ask something? Okay. Now, in the memorandum, what all clauses do we have? Name clause, registered office clause. What are the things which are not to be included in the name clause? You all have to remember all those words, patronage of government, all these things should not be included. If I want to change the name of the company, whose approval is required? Do I need to pass an SR or OR? Quick recap. For changing the name of the company, do I need to pass OR or SR? You have to give the answers, children. I can't see your answers. OR is required or SR? Yes, Soumya, Almas, everybody. Very good, Muskan. SR is required. SR is required. Great. And also approval of CG will be taken if the name is being changed. For changing the address, CG's approval is required only when you're changing from one state to another and fresh certificate of incorporation will be issued. For changing the object clause also, SR is required, and any company limited by guarantee not having share capital, in case they want to give any right to participate in the dividend other than the members, it shall be void. So you cannot participate in the dividend because company limited by guarantee is also a charity. After that, many number of time questions come related to entrenchment also, where we are talking about the formation of company. So the provisions of entrenchment for articles, you have to remember that there is a provision of entrenchment, means articles cannot be altered even by passing a special resolution. You minimum 90% of the approval is required. So for SR, we need 75% of approval. OR, we need 50% of the approval. But entrenchment means most majority, मतलब 90% of the shareholders अगर हाँ करेंगे तभी हम उस चीज को बदल सकते हैं. अब entrenchment कब होती है include? या तो formation में या amendment से आ सकती है by all the members in case of private company, and in case of public company by special. Then Spice E form is required for the new companies if you are having this entrenchment provisions, and it has to be filed within 30 days of adding this provision. Children, for memorandum, you have A, B, C, D, E tables. F, G, H, I, you have for the articles of association. Refer to the companies having share capital, not having share. Now, what is the doctrine of indoor management? We are not going to do all these concepts again, but yes, we are going to have a recap because I have very, very important questions related to this. Doctrine of indoor management. The doors of your house are closed, and what is happening inside the house, outsiders are not worried about that. So there is a doctrine which is an exception to the doctrine of constructive notice. So what was constructive notice? That when a prospectus, memorandum, and articles of association are acting as the doctrine of constructive notice, means whosoever is dealing with me, they are having an awareness and knowledge about what my company is doing. But whether the meetings are being held, whether the external proceedings are being taken care or not, that is not the headache of the outside. So doctrine of constructive notice provides the protection to the company. Indoor management tries to protect the outside. But there are still 3 exceptions of the indoor management. Who is going to answer me the 3 exceptions of indoor management? Come on, you're not CA foundation students, you're intermediate students. You have done this concept twice. You have revised it in foundation. You have given exams. Even in the inter, you have revised it. Raise your hands and explain me the 3 exceptions. One by one, you're going to tell me what are the 3 exceptions of the doctrine of indoor management. Again, the same students. Okay. Saman, we have a new child raising their hands. What's your name, child? Miss Saman. Yeah.
Good morning, ma'am.
Good morning.
The exceptions for indoor management were forgery.
Okay, so explain me forgery. Only one you have to tell. What do you understand by forgery?
If any person relies on any forged document, then it will be exception for indoor management, ma'am.
Absolutely correct. Very good, sir. So forgery means fake signatures. So if you're having a fake signatures, you're relying upon it. It is an exception, means here you cannot hold the company liable. So forgery is never covered as a part of indoor management. All right, Muskan, the next one.
Good morning, ma'am.
Good morning.
Knowledge of irregularity.
Knowledge of irregularity. What do you mean by that?
Ma'am, if the outsider has himself knowledge of any error occurring in the company and still he is interested in doing the business with the company, then he will not get benefit of doctrine of indoor management.
Absolutely correct. So you are yourself trying to cheat the company. You know that your borrowing power is still 50 lakhs as a director, but you still go and borrow 60 lakhs. That means the person who is dealing with the company, he is having the knowledge of this irregularity, this director, they will be held responsible. Company won't be responsible. Okay, Shagufta, very good, Muskan and Saman.
Hello.
Yes, Shagufta.
Ma'am, third है negligence.
Negligence. So what was that?
Ma'am, if with a minimum effort, irregularities with a company,
Very
but
nice.
then
I will explain.
endorsement not would be applied.
Simple example of Anand Bihari Lal that we have done. The accountant was having the power of attorney. He was trying to sell the company. That is not acceptable. That means you should have applied your brain and knowledge that can an accountant sell the company. So that is the awareness, having the knowledge of irregularity, negligence, the efforts which are being made. You're not trying to find out whether it is correct or not. And forgery, somebody is relying on the forged document, then the company can never be held responsible for the food. Now, I'm going to give you a small break. Please read Doctrine of Indoor Management, Constructive Notice, Doctrine of Ultra Wires, Memorandum of Association, because I am going to do with you questions related to this. So be prepared now because we are sailing in incorporation of companies also related to OPC. So ये concept revise करो break में and then we'll have the questions. All right, see you after the break. So we are taking a break here. Welcome back, students. Yes, am I audible now? All right, let's move ahead. So all those who are asking about the forms, incorporation of companies, children, I always keep telling you, an MGT has number of forms. You can give them a fair reading. If you can remember it, it's okay. But please, it might come for a 2 marks or a 4 marks related question. So that does not mean that your 95 marks question paper should not be prepared just because you were learning the forms and penalties. So everything has to be given a fair reading. You can memorize it well and good. Otherwise, on repeating again and again and again, when you sit for the exam, definitely the things come to your mind. Okay, so don't be so much worried about the forms. Okay. All right. So Act to override memorandum and articles, it says the provisions of the Act has an overriding effect. So children, if anything is written in the Companies Act and I have written something else in my memorandum, then what will we follow? As per section 6, it says wherever such things happens, Companies Act has an overriding effect. We will follow whatever is written in the Act and not what is written in the, it should not be in conflict with the provisions. If it is conflicting, then it is what? Now, how the company is incorporated, first of all, you have to decide whether you are following a public or a private company. You will reserve its name. A draft MOA and AO will be made and signed by the subscribers. How many people will sign it if it is a private company? 2 people will sign it. If it is a public company, 7 people will sign it. If it is an OPC, then at least 1 person should sign. All the statutory declaration of compliances has to be done. So there are 2 declarations. One has to be filed by the subscribers and first directors. Another is the declaration to be taken from a CA, CS or a cost accountant that everything has been compliant. Written consent is required for the people who have been nominated as directors. Submit these with ROC, you pay the fees and then you get the certificate of incorporation. File the declaration about address of the registered office. Do you think that we need to tell them the RO office also? Absolutely. You need to tell them where your RO is situated. Clear? So these are the steps of incorporation. After that, once the company is formed, INC 33 and 34 has been deposited, having your MOA and AOA. E-filing is nowadays done, children. The SPICE form is used. All these subscribers, if a subscriber is illiterate, somebody who wants to open up a company but does not know how to sign, his thumb impressions will be used. If it is a body corporate, then at least director or employee or officer authorized will sign. If it is an LLP, then it shall be signed by a partner, not himself a subscriber. What does it mean? Can a company be a member in a company? Of course, you have done the definition of body corporate. So subscriber can be a body corporate also and LLP also. If it is a foreign national residing outside India, his proof of identity has to be notarized. It's a public document. It's a government authorization has to be taken from the notary. And if he is a foreign citizen who is resident, who is residing outside India and is visiting India, then he or she should be having a valid business visa also. All these things needs to be checked if the company is being incorporated. Then we have seen OPC points. Any doubts in OPC? 1 person, no minimum paid up capital. Name of the person who is mentioned is the nominee. Its name can be changed at any time. No person can have more than 1 OPC. If Mr. X has opened the OPC, can Mr. X be a nominee of Y OPC also? Can he be appointed as a nominee in Y OPC? Yes or no? I can be a member in one OPC and I can be a nominee in one OPC. Okay? So yes or no? Why your answers are not coming, children? Am I audible? Okay, okay. Kirti has written. Absolutely correct. So you can be a nominee in another OPC. Yes, yes. Now I can see. After that, how many number of days have to be seen? 120 for having a resident. But what is written over there? You may be a resident or not. But Indian citizen is very, very important in order to become an OPC. After that, we had Section 8 point. Section 8 companies are for the charitable institutions. License is taken from CG and cancelled also by CG. What are the cases in which the tribunal might need to pass the order? If you do any offense under Section 8, 447 penalty is liable. If you contravene the provisions, means you're paying the dividends. Fine of 10 lakh rupees to 1 crore can extend, and directors will be fined 25,000 to maximum 25 lakh rupees. And officers shall also be liable for a fine of 447 if you do any fraud under Section 8 companies. But in what cases the tribunal can pass his order? If Section 8 company is violating, license will be revoked if it contravenes the provisions. But there was a provision related to the tribunal's order. If you want, I will show you from the study material. Okay, let me just show you. So I hope you have seen all these provisions. I asked you to give it a reading during the break. Doctrine of Indoor Management, Turkwan's rule. I hope no doubt in this. Constructive notice, ultra vires. Children, this is a very important concept. I'm going to do questions also out of this. But first, I want to cover major part of the chapter with you. Doctrine of indoor management is an exception, extension, alternative, or not related. It is an exception to the constructive notice. After that, we have discussed. So, acha, somebody was asking about these. This is just for a fair reading, for your understanding, nothing to learn in these examples, okay? But you should give it a reading because it helps you to give you clarification of the concepts. Section 8 companies we were discussing. Okay. Children, where is your Section 8 companies? Okay, let's do this question. A group of individuals forming a club, Budding Pilots Flying Club as LLC, to give classroom teaching and aircraft flight training to trained pilots. It was decided to form limited liability company for a charitable purpose under Section 8 for a period of 10 years, and thereafter the club was dissolved and surplus assets were distributed among the members as a usual procedure. Examine the feasibility of the proposal and advise the promoters. What do you think should have happened in this case? So it's a Section 8 company. Section 8 is always a company which is formed for a charitable purpose. It cannot take profits. It is only cannot pay dividend to its members. It only has to use the payment for the advantages of this club, whatever they have formed. Clear? So let us see 2.20 is the page. We will go back to it. But first, let us see the answer to this question, how you have to frame. So you will write Section 8 companies is formed for this objective. All these points will be given. License will be issued by CG. Its objective will be used only for the social welfare, commerce and art. It will apply its profits only for these objectives and prohibits the dividend. CG will give it a license. Here in the instant case, what is happening? They are taking a decision for a period of 10 years and dissolve it. This will not hold good because there is a restriction on using the profits and income for any other purpose other than promoting its objects. This restriction in the application of surplus assets in the winding up is provided in subsection 9 of section 8. Hence, the proposal is not feasible. Now, do we need to write this subsection 9 of section 8? No, you simply can refer to this provision wherein it is clearly written that it is prohibits its usage of the profits for any other objectives. Even if you are not writing this provision of subsection, then also it's absolutely fine. So let me just show you the provisions of section 8 companies. So this is what you have to remember over here. ROC regional director will be giving for the alteration. License will be given. These are the 3 points which is given over here. Earlier, a small company can never be incorporated as Section 8 company. Firm can be a member in Section 8 companies. All these points that you have read in foundation, significant points, same you can remember. Spice E form is used. So this is interesting. Spice E form, E plus form is used. Spice form is used for incorporating companies. Specifically for Section 8 company, we use Spice E form, INC 32. A declaration will be given that all the provisions have been considered and compliance is being done and the profits, the provisions are complied with. Okay. Alteration of memorandum and articles. Here, the power has been delegated to RD for altering the memorandum and articles. Otherwise, CG had the power. Now it is given to RD, and for the alteration of articles, it is given the power to ROC. Then if you want to convert yourself, SR is required, explanatory statement is required, RD's approval has to be taken. I'm revising it with you because I have a question related to this coming up. Okay. And attach all the service along with the, how the notice has to be served. All these notice has to be given to all these people by registered post or delivery. If any representations you want to make to the RD within 60 days of receiving the notice, opportunity will be given that you can go and make an application to the RD. Also, the company will publish a notice in the newspapers, 2 newspapers. That is, now we are planning to convert ourselves. Company will file all the financial statements and annual returns with the RD and all the returns submitted. In case the application is filed after 3 months, the financial statement position by a chartered accountant signed should also be given within the 30 days of filing. Then RD will pass an order approving the conversion. An opportunity of being heard will be given that we are going to convert you into either a public company or a private limited company, because children, Section 8 company does not use the word private limited or public limited behind its name, although the liability is limited. But if you are converting, this entire procedure has to be followed for the conversion. And then general meeting में SR pass होगा जिसमें आपका articles and memorandum will be altered and a fresh certificate will be. But when does your license gets revoked? Now, this part was the new part. This was not there in foundation. This is the new part. Rest, everything is same. Revocation happens if you contravene the provisions and if you're conducting the affairs in fraudulently, then words limited or private limited will be put after your name. Company will be wound up after this. Excessive assets after dissolution may be transferred to another company or sold out. Or the company will be amalgamated to another company, and this is your punishment for the penalty if you're doing any fraudulent act. So here is a summary of subsection 6 to 11. Where has it gone? Yes. So this fine and penalty is important of Section 8 companies. Either you will be winded up, the surplus assets will be transferred to similar one, amalgamating, and insolvency and bankruptcy fund will also be, amount will be transferred to them. Is that clear? Everyone is clear? We have done one question also from study material related to this. Now, Section 9 is very, very simple. Company becomes a corporate legal entity having perpetual succession. You all know about these points. Subscribers to the memorandums will become the members of the company from the date of incorporation. It can hold property, it can sue and be sued in its own. Now, memorandum of association also, all the clauses we have discussed from the presentation also. What happens for the identical, resemble नहीं करना चाहिए किसी के नाम से, undesirable नहीं होना चाहिए, CG's approval is required if it is not registered name. All these words you simply have to give it a reading. Now, all these examples that are given is just for your reference. You can read them, that the addition, deletion, what kind of names you can use. Must have read it while you were studying this chapter. No need to keep reading it again and again during revision. Revision के लिए name clause क्या है, cancel कैसे होगा, reserved name, all these provisions have to be remembered. Is that clear? Let's go back to the presentation. Now, before we go to the registered office clause, let me see some of the questions related to the name clause and other parts. So the role of doctrine of indoor management is opposed to the role of constructive notice. Person not being members are always protected by the doctrine of indoor management. Explain the doctrine of constructive notice will apply on. Now, what is the content of the question? It is a straightforward question, children. He's simply asking you what is the indoor management. You will give them the summary. Turquoise rule will be mentioned and give the 3 exceptions that we have just discussed. This is how you will have to frame the answers, that people who are dealing cannot have the knowledge about the irregularity happening inside. So it is a protection given to the outsiders that they will be protected. How were the outsiders protected? What happened in case of Turquoise rule? Anybody would like to explain in the class? Anyone would like to share? Turquoise rule, anyone remembers? Indoor management, Royal British Bank versus, if you don't remember, you want me to repeat it, please tell me, children. All right, so it happened in this case that there was a liquidator, Mr. Turquoise was appointed. And he decided that since the company has taken a loan, a bond was signed, but it was not within the authority of the directors to sign this bond. Hence, the bond could not be repaid. But the bank said that we are not supposed to know whether the resolutions, internal things have happened or not. Internal matters is not a matter of public knowledge. Outsider will not have this knowledge. And if not the doctrine, company could discard. Otherwise, the company will escape the liabilities from the creditors and denying their authorities to work on its behalf. Therefore, indoor management was formed. However, there are certain exceptions. Outsider having a knowledge of irregularity, if it is a negligence, if it is a case of forgery, then it will not. Clear? Okay. Let's do this question. Mr. Raja, along with his family member, is running a successful trading business. He is capable of developing his ideas and participating in the marketplace. Therefore, he formed a single economic entity, that is OPC, with his brother, Mr. King, as a nominee. King withdrew his consent as a nominee. Can he do that under the provisions of Companies Act? First of all, can Mr. King, who has been appointed as the nominee, can he withdraw his consent to act as a nominee? Yes or no? Muskan says yes. Shifibon says yes. Yukta, Soumya, Vishal, Iram, Harshida. Everybody says yes, because the third point of OPC section 3 tells us that yes, you can withdraw it. Do we need to take a written consent? When he's appointed, written consent is taken, he can withdraw. Whether the following individuals are eligible for being appointed as a nominee or as on 5th May 2020, because अब आपने withdraw कर दिया तो nominee को score को point करना पड़ेगा. Mr. Sham, son of Mr. Raj, 15 years old. Can Mr. Sham, who is 15 years old, appointed as a nominee? Very good. Vishal, Trifipol Yukta, Tanu Almas, Soumya, no, because he's a minor. Nancy, Saxena, Ram Dulari Ram, everybody, Harshada, excellent. No, minor cannot be appointed. Miss Devaki, an Indian citizen. Okay, let me open it. Kirti, good. Devaki, an Indian citizen, sister of Mr. Raj, stays in Dubai and India. She stayed during the period from 2nd January to 16th August. Thereafter, she stayed in India. Can Miss Devaki, an Indian citizen who has stayed less than 120 days in India, how many days she is staying? August 2019, she came. Thereafter, she left for Dubai. So during the previous year, March, April, May, June, July, August, you have to consider. Please tell me, can Ms. Devaki be appointed as the nominee? Yes or no? Do we need to see 120 days or not? Everybody says yes because she's an Indian citizen. She can be appointed as a nominee. Are we saying it on the basis of 120 days also? Yes or no? Absolutely correct. We simply have to see Indian citizen. And the third one is very, very interesting. Mr. Ashok, an Indian citizen residing in India, who is presently a member of another OPC. Can Ashok be appointed as a nominee? He's already a member of one OPC, can be appointed. Yes, provided he is not a nominee in another OPC. Interesting question. Very nice. So section 3 memorandum tells us in case of the subscriber's death, one nominee has to be appointed. His name will be given in the memorandum and filed with the ROC. First, give this provision. He can withdraw his consent. Therefore, king can withdraw his consent by giving a notice and writing. This is the first part of the answer. Minor cannot be appointed. Very good. Natural person, Indian citizen can be appointed. A person shall not be more than one OPC at any time. Here, he is a member, not a nominee in any OPC, then he can be appointed. So, no. All your answers correct, 6 out of 6. Give yourself marks and move ahead. Red Limited, now twice this similar question has come in the exam. So, I have noted it down on 2 places. Red Limited was incorporated on 1st April 2014, is facing severe effects of depression of economy due to its bad financial status. Most of the members have started withdrawing their holding from the company. Company had 250 members on 10th January. By 15th January, 244 members had withdrawn their holding. Read the question very carefully and tell me what it is asking. Raise your hands and answer. Read the question very carefully and then raise your hand. The similar question is, what is the minimum number of persons required to form a private company? He is giving you a hint. When the number of members fall below the limit, what will happen? But I want, for the Red Limited, I want proper written answer, provisions, facts, and the conclusion. Nancy Saxena, okay, you want to answer this one?
Yes, ma'am.
How do you pronounce your name? Nancy.
Yes, ma'am.
Okay.
Ma'am, in case of private company, the minimum person required is 2, and in case of public company, it is 7. अगर नंबर ऑफ मेंबर 7 से बिलो जाते हैं और जो बचे हुए मेंबर हैं वो 6 मंथ से ज़्यादा कंटिन्यू करते हैं तो मेंबर विल बी सेवरली लायबल फॉर ऑल द लायबिलिटीज जो उसके बाद में पीरियड होगा उसमें जो लायबिलिटी को क्रिएट करेंगे.
So here, Mr. A's, in the case of Red Limited, what will happen to them since the number of members are now only 6? Is it okay?
No ma'am, Red Limited is a public company. So मैम उसको 6 महीने के अंदर अंदर अपना या तो मेंबर्स को पूरा करना होगा और अगर वो नहीं पूरा कर पाता है तो 6 महीने के बाद जो भी वो ट्रांजेक्शन्स वगैरह करता है उसके लिए वो
Absolutely, Mrs. Saxena. Wonderful answer given by you. Well done. And I'm so happy to see the confidence level also of the students going up, that you're taking up the courage, raising your hands and answering. So well done, students. I'm sure you all are going to come out passing with flying colors. So this is exactly what she told, the provisions you will write. In the given situation, number of members is 6. You have continued the business during the period 1 month. So all the members will become severally liable for whole of the debts contracted during that time. Is that clear? Section 3A provision will be applicable. Few of the sections, children, when you repetitively do the MTPs, RTPs, you tend to learn the sections. So write the correct section if you remember. If you don't remember, never write a wrong. Let's do another question. Articles can contain the provisions of retrenchment. This can be the straightforward question. Yadav Diaries is the case study question. Read the case study and answer me. It's clearly written, while as per section 14, it can be done by SR. We are asking for the 90% resolution for future of the shares. Raise your hands and answer me for this one. What are the provisions for entrenchment? How you can include it? Okay, Miss Yukta would like to answer this one. Please answer.
Entrenchment means when we required a percentage more than SR, generally it is to be considered as 90%, and it can be added at the time of incorporation in the form SPICE plus INC 32, or we can add it by altering MOA and AOA.
So for
In
altering MOA, it will be required.
Sorry, ma'am.
What kind of provisions will be required for making an alteration?
For public company, we need to take the majority of the consent of the shareholders, and for the private company, we need to take the unanimous consent.
Very good. So Yukta, we'll pass a resolution taking the permission from the members, and also it needs to be filed with the ROC that this is the provision of entrenchment that we have included. Either it is included on the formation or by amendment in the articles by passing an SR in case of a public company. In case of private company, all the members' consent is required. Everyone is clear upon this point. Can we move ahead? Ayushi Verma, Harshita, all your answers are correct. Anybody who has given the answers for this one? All right. Okay, Mr. Shamlal is a BTech in computer science. He has promoted an IT startup and got it registered as private limited. Initially, he and his family members were holding all the shares. While drafting AOA, it was included Shamlal will remain the director. Mr. Mehra, close friend of Shamlal, was warned him that in future 75% of the most shares are held by non-family members only by passing SR. The relevant articles can be amended and Mr. Shamlal may be removed from the post of director. Mr. Shamlal has approached you to protect his position as a director for lifetime. Now, what is this question 5 asking you for? It is again related to section 5 articles of association. So see how many times in exam these questions have come, children. Specifically asking about the articles of association. So let's proceed ahead. So subsection 3 tells us about the provisions of retrenchment. Similar question in a different way. It can be altered only if the conditions are more restrictive than those appeared, cannot be met by SR. Then we try to include the entrenchment by passing an SR, but entrenchment makes it difficult. So manner of including has to be told either on the formation or by amending the articles by all the members and SR in case of public company. Notice has to be given to the registrar whether on the formation or amendment whenever you are including the entrenchment provisions, notice has to be given. So what will we conclude? In the said situation, IT startup company is a private company. Therefore, SR will be required to be passed. We will get the articles all altered by agreeing all the members. Sorry, it is a private company. So all the members need to agree, whereby the amended articles will say that remove him. Only 95% of votes are in cast of the favor and give notice of the same to the registrar. So this much restrictions and provisions have to be. What is this restriction that they have included? That at least 75%. 75% is for the SR. So here we have included entrenchment. Only if the 95% members will cast in favor and give the notice, then he can be removed from the post of director. So the restriction protection has been given to the Shamlal that cannot be removed very easily. Clear, eh? What happens if false information is furnished? What are the powers of the tribunal? This is what I was asking you. What actions can be taken by the company in case of giving the false information? So Ram has got his company registered in the state of Telangana. False information was given knowingly. What kind of actions can be taken up, children? Order of tribunal can be given. He can either make the liability unlimited or he can pass the orders for the regulation management, direct the removal of the name, pass the order as he thinks fit. Before passing, reasonable opportunity will be given of heard and the transactions which have been entered should also be taken into consideration. Is this clear? Also, the promoters, the person named as the first director, will have to give a declaration at the time of registration. They will also become liable under 447. He has asked you the penalty also, na? So they will become liable under 447. One of the matters in the Articles of Demand Foundation incorporated under Section 8 was altered by passing a special resolution and thereafter intimation was given to the registrar. Such alteration was opposed by Dhwaj, a partnership firm which is also a member, that the alteration was not valid. Please decide whether the contentions of Dhwaj was valid and whether he can be a member. First of all, can a firm, Dhwaj and Company is a partnership firm, can it be a member in Section 8 companies? Yes, ma'am or no, ma'am? Tanu says no. Why do you say no, Tanu? Everybody has written yes. That's correct answer. So partnership firm can be a member. सिर्फ यही तो Section 8 company ही ऐसी चीज है जिसमें firm member हो सकती है. Otherwise, firm is not an artificial person. Firm cannot be a member, but in Section 8 companies, firm can be a member. Everyone is going to read section question number 7. And I want a proper formation of answer for Section 8 companies. Everyone will read it and write the answer. I give you 2 minutes, write the answers in the chat box. Many of you have given the correct answer, but some are still writing yes or no. Okay. Good, Nidhi. I've read your answers. Today you are also giving good answers. Very nice. Prasad. Pavan Kumar. एग्जाम्पल एक बार समझा दीजिए पेज नंबर 2.10. Okay, Pavan Kumar, we will take it up after this. So, this is your correct formation. A company under Section 8 cannot alter its provisions except the approval of central government is required. I just now told you, instead of CG, the power has now been delegated to ROC. For conversion, it was RD. For alteration, it is with ROC. Firm can be a member in the matters are altered by passing SR. Therefore, intimation will have to be sent. It is necessary to take the previous approval of the registrar of companies, which was not done in the present case. Hence, it is not valid. Section 8 being a member, and hence he can be a member. His contention is also valid. Do you agree? Answer number 7 is clear to everyone. Children, can we move ahead? Very good, Asta Sethi. Correct answer. RD nahi hai beta. It is ROC. And don't write the incorrect forms, please, children. If you don't remember the form numbers, leave it. In the answer also, we have not given you any form numbers. He's not asking you specifically for the forms. Okay, so we get excited. We try to learn all the forms, but if you give wrong forms, then it is not good. Very good, Iram. Iram B. Shah has included all the names. ROC भी ले लो, RD भी ले लो. मैम अपने आप decide कर लो किससे करवाना है. Approval from all these. No, you have to be very sure. Okay, for conversion, it is RD. Nancy Saxena is asking, ma'am, body corporate में firm आती है क्या? Never it is included in the definition of body corporate, right? It is only Section 8 companies में firm को इजाजत है member बनने. Otherwise, firm is not an artificial person. Now another question, group of individuals. I think we have done this club question. We have already done. The proposal is not feasible. Mr. Dinesh incorporated a new private limited company and wants to commence the business immediately. Please advise them what procedure they have to follow. Can you commence the business immediately? ये क्वेश्चन पढ़ लो एंड फिर मैं बंद करती हूँ इसको ताकि मैं चैट बॉक्स में आंसर्स रीड कर सकूं. These all are examination questions, children. Tell me the answer number 9. Now write in the chat box because I can now see your answers. When I close the screen, I can see your answers. Section 10A is applicable over here. Within how many days the declaration has to be filed? Give your answers, children. 180 days. Very good, Soumya. Others? Ayushi Verma. Good. Tanu, Shifimol. Everybody has now. Asta says no, he has to file and register. Very good. Even the RO office intimation has to be sent. Very good. Very good. So he has to comply with 2 important requirements. Not 18 days, Pavan, wrong. 180 days hai beta, 18 days nahi hai. So 180 days of the date of the company is formed. He will have to file. Every subscriber has paid up the value agreed at the date of making the declaration. And also a verification of its RO office has to be complied with. Then only you can start the business. Now let's open the question, example 2.10, which somebody was asking. Example on page number 2.10 पूछ रहे हो बेटा? Amar Akbar Anthony along with 5 of their friends member of Harmony Limited. They died on 18th August. Number of members reduced to 6. Everyone was aware about it. It continued its operation without. What will happen in this case? They have took a loan and defaulted. Lender can sue the company or Anthony or rest of the 5. All the members will become jointly liable. Pavan Kumar, beta, इसमें क्या नहीं समझ आया बेटा? अगर number of members less than 7 से 6 हो गए हैं, ये आपकी लिमिटेड कंपनी थी, 7 होनी चाहिए थे, अब 6 रह गए हैं, तो मोर देन 6 months अगर आप बिजनेस करते हो तो आपके पर्सनल एसेट्स भी लायबल हो जाते हैं. यू बिकम जॉइंटली एंड सेवरली लायबल. The members are operating more than 6 months knowingly with less than the minimum number are liable for the debts contracted during the period since the number of members were reduced. No. Such members are liable for the debts contracted during that time, means after the 6 months they are liable. Okay? Is that clear to everyone? So you don't become liable since the date, but after 6 months have passed, from that date you become liable. Let us go back to the presentation. Now, registered office of the company, section 12, very, very important section. It is a physical place which is receiving all the communication and notices. A company within 30 days of its incorporation have to tell about the RO office, and verification also has to be done, furnish it with ROC. Labeling of the company, कहाँ नाम लिखना है RO का? Where have you have to fix the name and address on the outside every office? The name engraved in legible letters on its seals, on its phone number, tax number, everywhere it has to write. Name changed by the company during the last 2 years. Company will paint the name. The former name should also be written in brackets for the period of 2 years. In case of an OPC, the words OPC Private Limited has to be engraved and fixed whenever you're having an OPC in your name. And if the registered office is being changed, for changing from one state to another, within the state you have changed your RO. First is this situation. Second is within the state from one ROC to another. And third is a situation where you have changed your RO office from one state to another. Within a state from one city to another. So you are in Maharashtra, that is a common state, and your office was in Mumbai, and now you have shifted your office in Pune. What will happen? What kind of resolution is required for shifting the office from Bombay to Pune? SR is required or not? Or board resolution से काम हो जाएगा? SR will be required. Very good, Ayushi Verma. Excellent, Harshada, everybody. Tanu, SR will be required. Why? Because city change हो रहा है. Okay? Plus CG's approval. Okay, Yukta says CG's approval is also required. Soumya, SR is required. Good. If I am shifting my office in Bombay from Juhu to Bandra, then what is required? Bombay में ही shift हो रहा है, कहीं बाहर नहीं जा रहा, या दिल्ली में ही CP से कालका जी shift हो रहा है. अगर within the same city हो रहा है, फिर क्या requirement? OR is required. Okay. Board resolution will be required. Very good. Then OR or board resolution is also fine. Then we don't need SR. Clear to everyone? Ram Dulari, all the answers given correct. Very good, beta. Shagufta. Good. If we are changing the office within Bombay only, the ROC has been changed. It was ROC under Juhu branch. Now we are going to different ROC at Bandra. If ROC is same, city is same, BR or OR will be passed. Within the same state, city is changed, SR and notice to ROC. From one ROC to another, SR will be required. RD's permission is required. First 30 days, 60 days filing, and then 30 days. This is the conclusive evidence that the office has been changed. And if you are changing from Maharashtra to Punjab, you are changing. then approval of CG is required. Yukta, not here. Within the city, you don't require, but if your state is only changed, then CG's approval is also required, and a fresh certificate of incorporation will be given. Now, since section 13 is important, we will also read section 13 from the module also. Company may alter the provisions of memorandum with the approval of the members by passing SR. All these provisions of subsection 456. Company will file with the registrar. Change in the name will be effected only by taking the approval from central. Now the power is with us. However, the words additions private on the conversion will be written. Any change, registrar will enter the new change in the form number INC 25 with the new name. So it's okay when read the form. No need to remember all the forms. Company will not more than, so similar provision that we have read in section 8. Here it is a different, all the forms are different. So again, newspaper advertisement has to be given. Central government will file the change of application within a period of 60 days. So here you can see, children, the provisions of 30 days, 60 days and further 30 days have to be followed. Alteration of the memorandum for RO will not have unless it is approved by the CG. Memorandum along with the approved proposed alteration, acknowledgement of the service has to be given, copy of board resolution has to be filed. वकालतनामा भी बोलते हैं इसको, हिंदी में क्या बोलते हैं? वकालतनामा. एंड लिस्ट ऑफ क्रेडिटर्स एंड डिबेंचर होल्डर्स भी चाहिए. क्यों चाहिए होंगी? देखने के लिए कि क्रेडिटर्स का पैसा वगैरह तो दे दिया ना, गड़बड़ तो नहीं कर रहे हैं कहीं. Okay, so if any change in the alteration is happening, list of creditors, debenture holders, their consent also have to be taken. Then you will issue in the newspaper within 60 days. CG has to satisfy that the consent of creditors and debenture holders has been taken. Sufficient provision has been made to give their obligations and security has been provided. This is important point. Examiner asks you about these points. When the alteration results, the certified copy of the central governments and the alteration has to be filed within 30 days. So here 60 days and 30 days is an important provision. Now, what happens if you're changing your object for which the money has been raised? Then again, you see children, you are taking money from the public. Prospectus issue होता है company के case में, जो हम अगली class में समझेंगे. Prospectus, share capital and debentures and all these details. So company is raising the money from the public. It has to make sure that what is the purpose for which the money is being used, any unutilized money, particulars of the alteration, all these things have to be utilized for the objective for which the company is formed, and it cannot use the money raised from the public for any other purpose. So any alteration over here, dissenting shareholders will be, we have decided to change our objective. We were into shoe business. Now we are starting ready-made clothes business. Don't you think some of the shareholders will be upset because of this? They should be given the opportunity to exit. They will be asked to leave the organization. Alteration will be made within 30 days. This alteration has to be filed with the ROC. Then we have alteration of the articles of association. I hope it is simple. 60 days SR resolution is required to be passed. Every alteration has to be filed with the CR, and alteration will be valid and having as if it is original contained in the articles. So this was a brief revision of your incorporation of companies. We still have few questions, children. Let me read your doubts. Yes, Yukta, absolutely correct. Dissenting shareholders will be given an option to exit. XY Limited has its registered office at Mumbai in the state of Maharashtra. For the better convenience, company wants to shift the registered office from Maharashtra, from Mumbai to Nasik. What formalities are to be complied with? Now, this is a very important question which will help you to do a writing practice. So I give you 2-3 minutes, write down in the chat box. I am going to check what answers you have. Ayushi Verma is the first one to give the correct answer, but I want you to write the answers in the proper form. Mrs. Saxena, we are not changing the ROC. Please make sure over here we are simply changing the city is being changed in the state of Maharashtra only. Very good answers given by all of you. So this is how you have to write the answer. Under section 13, the process has been laid down how the memorandum gets altered. Since the location is being shifted, only the names of the state in which the RO is situated from Bombay does not result in the alteration. Hence, provisions of section 13 will not apply. Why? Because the state in which the RO is situated, only the address is being changed. It deals with the registered office. The change in the registered office from one town and city must be passed by passing an SR. Registrar will remain the same. Here we are presuming. So there is no need to take the confirmation for such change from the RT. So इसमें simple answer था section 12 के according आपका SR पास होना है and RT की permission आपको नहीं चाहिए क्योंकि आपका city and state and ROC change नहीं. Another important question, that is question number 11. The first decisions and proposals, RO is being shifted from Thane to Dadar. Both the places are within the jurisdiction, means ROC is not changing. They have passed the SR, but they have not taken the approval of RT. Anybody would like to raise their hands and answer me the first part? Exam question number 11. Okay, yes. Speak.
Yes, ma'am. In first condition, it is valid because ROC is the same, and for same ROC, we need to pass SR.
All right, Muskan, you also wanted to say something? So children, everyone, you agree? This proposal is valid, yes or no? Absolutely correct. So it says in the first case, RO is being shifted. Section 12 deals with whenever the RO is good, Yukta, put your hand down. RO outside the local limit, if it is going, it will SR is required. No approval of RD is required at both the places because ROC is the same. Hence, the proposal is valid. RO is in Mumbai, within the jurisdiction of the Mumbai, Maharashtra state. Corporate is in Pune, under the Pune ROC. A Limited proposed to shift its corporate office from Pune to Mumbai under the authority of board resolution. अब हम क्या चेंज कर रहे हैं? हम स्टेट सिटी चेंज कर रहे हैं. सेकेंड पार्ट में वी आर चेंजिंग द सिटी फ्रॉम पुणे टू बॉम्बे. ओनली युक्ता इज रेजिंग हर हैंड्स. व्हाट अबाउट अदर्स? स्लीपिंग? Okay, Dhruv, we have a new name. Harshita is also there. Okay, Dhruv.
So since it's only a change in the corporate office, it does not require any permission from the registered regional directors.
For the second one, we are asking. So under the board authority of board resolution, you mean to say it's correct?
The proposal is valid.
It is valid, yes. Good, Dhruv. Well done. Yes, Muskan. Anything else?
Ma'am, from one state, within a same state, from one ROC to another, special resolution is required and permission of regional director is also required.
All right. But what is happening in this case? We are changing it within the same city, within the same state. Okay, here the state is not being changed, Muskan. Here only the city is being changed. So passing a board resolution is also valid. Section 12 talks about the registered office only. In the second case the corporate office is shifted from one city to another under the authority of board resolution, it is valid. Why? Because we just did this one. Let me show you again. Within the same city child, if we are doing, then board resolution is also fine. Okay, this one. What is the third one? Changing within the local limits. Board resolution is fine. Third one, who would like to answer? Within the local limits of the same city. Simple board resolution would be fine in this case, okay? Now, one more question and then we will have quick discussions of the questions from the study material also. I give you 2 minutes. Frame the answer for this question properly in your notebooks and raise your hands and then speak it up. Everyone is going to write these answers. What about others? Have you solved this question? It is a very simple question, children. I would appreciate more hand raise. Only Yukta has raised a hand. What about others? Okay, good. Yes, students. So Yukta, Asta, Tanu have raised their hand. Still, we are waiting for mothers. Let's hear from Tanu. Yes, Tanu.
Yes, and they can raise for other purpose क्योंकि but उन लोगों को more than 2/3 मेंबर से अप्रूवल लेना पड़ेगा लेकिन अगर वो किसी कंपनी में इन्वेस्टमेंट के पर्पस से यूज करते हैं मनी को तो वो लोग नहीं कर सकते हैं.
All right. Well tried, Tanu. Asta.
Yes, ma'am. Here, section 13 applies as it changes the objective for which it collects the money from the public. So it
Hmm.
needs to pass SR through postal ballot, and
Mm-hmm.
then has to file with the registrar within 30 days of passing of the SR, plus advertisement also to be given. And if there is any dissenting shareholder, then opportunity to be given to leave.
Very good. Excellent. Excellent. Well done, Asta. Well done, Tanu. Yes, Yukta, any other point to be added?
No, ma'am, exactly the same what she said.
Very good. Well done, all of you. And those who have given in the chat box also have read your answers. Wonderful answers. So section 13 will become applicable whenever you're raising the money. You have to use it as per the requirements for which the money has been raised. Details of the resolution will be published in the newspaper. Absolutely correct. At the place where the RO is situated, and also on the website you have to publish it. Presenting shareholders will be given an opportunity to leave. Company will have to file the copy of ROC, SR with the ROC within a period of 30 days. And then only the alteration will become effective. You want to do certain more questions, children? Are you enjoying the questions? Are you feeling that your मैम एक बार क्वेश्चन समझा दीजिए शगुफ्ता उस क्वेश्चन में वो सिंपली आपसे ये पूछ रहे हैं कि मैं अगर अपना ऑब्जेक्ट क्लॉज बदल रहा हूँ कोई चेंजेस ला रहा हूँ तो मैं वो कर सकता हूँ वो कहते हैं आपने कंपनी से पैसा लिया है तो कंपनी का पैसा उसी चीज के लिए यूज करना है जिसके लिए मेंबर्स ने शेयर होल्डर्स ने शेयर्स खरीदे पैसा लिया सो अगर आप कुछ भी चेंज करते हैं तो आपको स्पेशल रेजोल्यूशन पास करना है और उसे आरओसी के साथ फाइल ओके बेटा शगुफ्ता क्लियर नाउ All right, students, everybody has given the correct answer. So I hope you're enjoying these questions and it is giving you a quite better way of revision. Okay. All right. Thank you. Welcome, Shugufta. Company can do the alteration. Harshada, everyone has given the correct answer for the previous one. Okay, so let's do one more question since we have time. Soumya, all your answers were correct. That's good. Prem Kumar 220. I hope you have understood now that we have already discussed Section 8 companies. Okay. So Manglu and his friends got registered a company in the name of Taxman Advisory Private Limited. It is a registered trademark. After 5 years, the owner of the trademark came to know about the same and filed an application with the relevant authority. Can the company be compelled to change its name by the owner of the trademark? Can the owner of registered trademark request the company and then change the company and names? So change in the name से related का question है. You have to write the answers. Asta has already raised her hand. Asta, this is for the answer or query? It's a very simple question. Yukta has raised, Muskan has raised her hand. What about others? Others also want to raise their hands. Ayushi Verma, Dhruv, Prem, Hiram, Almas, Soumya, Piyush. Anybody who would like to answer? Kripa, M. Sanskar. Yes, Tanu, all those chapters will also be taken up. Don't worry. Very good. 3 years period. Everyone remembers, huh? Section 16. All right. Yes, Asta.
Ma'am, it cannot compel the company to change, although can request because 3 years have already been expired.
Very good. Excellent answer. This was the conclusion. So Yukta, would you like to tell me the provisions of the case? So let's see. Section 16 says that the company registered with the same name, CG thinks it's identical, or the trademark feels that the same name has been used, then within a period of 3 years, he has the time to file the application. And after that, within 3 months, the OR will be passed from the order of the CG and changes will be made. Company will give the notice to ROC within 15 days of the CG's order. In the owner's case, in the present case, filing of obligation after 5 years is taking place. Within 3 years, it has to be filed. Company cannot be compelled. Absolutely correct, the first part. However, Section 13 says company can change its name by passing SR and taking the approval from the central government. अभी पढ़ा था ना Section 13 में भी. So if the owner requests the company for the change of its name, company can accept the same and voluntarily it can change as per the provisions of Section 13. Clear? So last question for today's class is second last. Board of Directors of Sindhu Limited wants to make some changes and to alter some clauses of AOA which are to be urgently carried out, which include the increase of authorized share capital, issue of shares, increase in borrowing limits, increasing the number of directors. What is the procedure to be followed for altering the articles of association? How does the articles can be altered? Yes, Astha, that same form is required for consent of nominees. It's okay. Don't worry about that. By passing SR. Okay. What else? What else you have to do the procedure for altering the articles? So Section 14 gives you the provisions for powering the altering or adding in the articles. SR will be required to be passed subject to the provisions and conditions of MOA. SR will be passed. You have to file it within 15 days with the ROC. Any alteration will be valid as per the provisions of the Act. Every copy of this has to be given. If company makes in default, every officer will be liable for a fine of how many rupees? Penalty of 1,000 rupees if any default has been made. Section 14 and 15 provisions will become applicable over here. Question number 15, last question. Such a lengthy chapter, and I'm glad we have completed it within the time period. And yes, my goodness, sections also remembering now. Section 19, students have started writing the name of the section also. Good. Shifimol, good. So I want you all to write the answers in the chat box itself now. Very good, Yukta. Tanu, good. Pavan Kumar, okay. So let's read the answer. Section 19, absolutely correct, mentioned by you. Company will not hold either by itself or through the nominees. Holding company cannot have any of its shares in the subsidiary company. It will be held void. However, there's certain exceptions. If the subsidiary company is holding it as a legal representative of deceased of the holding company, or it is holding as a trust, or where the subsidiary is a shareholder even before it became, that means you were a shareholder before, now you have become a subsidiary. In that case, it will not have a right to vote in the meeting of holding. In the given case, one of the shareholder of holding company has transferred its shares at a trust shareholding, but it will hold it in the capacity of a trustee. Therefore, we can conclude S can hold the shares in H Limited. So well in time, we have winded up the provisions of chapter number 1, preliminary, as well as chapter number 2, incorporation of companies also. So I hope no doubts to you, because we have cleared all the doubts also in between the class only. Let me see if I can ask you one more question. Okay, one question I wanted to do, which is November 22 question, because we still have 5 minutes. Are you enjoying the class, students? Yukta says, thank you, ma'am. All the concepts are very clear now. So that's great. Well done, child. Shifi Mole, correct answers given, beta. Okay, beta, Astha, in which example you're having a doubt, write down in the chat box. I'll open that. Hanji Pavan, you will get all these recordings. Don't worry. Okay. Astha, you can write down. I'll open the study material, beta. Which example? Thank you so much, Muskan. Muskan has written, ma'am, you're a very wonderful teacher. So thank you so much, child. Even you all are very wonderful students. You have been responding it so nicely and answering back. That is how we try to do a interactive session by learning and revising also. Ma'am, page number 2.48. Okay, I'm just taking out page number 2.48. Which example number, child? So I told you these are just the points. You don't have to go into much of the details of these paragraphs that we have given. This is just for a basic understanding. So it says articles of law contain the clause that the Brownie should be a director and not be removed. However, if removed earlier, he brought an action to restrain him. There was no contract between Brownie and company. No outsider can enforce. Here, if you want to include an infringement provision, it would have been a different thing. But since he is considered as an outsider, is trying to remove him, therefore it is a different clause. Okay. So this kind of things, just a general reading can be given to it. You don't have to lay so much stress on this. Again, the Rayfield examples I told you, na, this is just for the reading part. Okay. Asta, you can write down in the chat box. Chapter number 1. Pavan Kumar, what doubt are you having in chapter number 1? Ask me. Yes. So I cannot see any more doubts. Now in the next class, children, I will be taking up the class on 11th July, that is Friday. I hope it's clear, children. Now let me just close it. So I am going to do. So it's okay, Asta. There might be some mistake in that. So don't worry about that. Don't waste too much time on unnecessary things. Pay more attention towards the section related, like you have been answering good in the class also. Just pay attention on the provisions. There can be some of the error over there. So it's okay. Just leave it and move forward. Okay, all those paragraphs which I've shown you are just for understanding and clarity of the thoughts. If you have understood the concept, you can apply your knowledge and you can answer it accordingly. Okay, so now I was telling you, so come prepared with chapter number 3 and 4. You've already done 1 and 2 today. You have been answering very well. All of you have answered in the chat box also. So well done, students. And I hope you have enjoyed today's class. Now geared up for prospectus and share capital. Read the chapters, come prepared so that we can do n number of questions and your proper revision will be taken care of. All right. I hope no more doubts. Thank you. Thank you so much. Thank you, Tanu. I can just read the thank you messages now. No more doubts are coming up. If you still have any doubts, okay, Asta, I will check about that INC3 form. Don't worry. I will tell you on 11th. All right. Yes, I cannot see any more doubts. So let's wind up the class now. And children, please revise share capital and debentures and prospectus also. All right. Okay. Thank you, Kushi Gupta, Yushi, everyone. Thank you, children. Cannot see any more doubts. Yes, sir. I think we are done. Students are done with their doubts also. Yes, sir.